Magandang araw po sa inyong lahat at welcome po sa isa na namang video ng Payo ng Abogado. Ang pag-uusapan po natin ngayon ay ang The Revised Penal Code, Chapter 2, Justifying Circumstances and Circumstances which exempt from criminal liability. Ang videong ito ay hatid sa inyo ni Attorney Bernardo M. Luceres. Simulan na po natin. Justifying circumstances and circumstances which exempt from criminal liability. Article 11. Justifying circumstances. The following do not incur any criminal liability. Number 1. Anyone who acts in defense of his person or rights, provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Number 2, anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relatives by affinity, in the same degrees and those consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite, in case the revocation was given by the person who acts, that the one making defense had no part therein. Number 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Number 4. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. Third, that there be no other practical and less harmful means of preventing it. Number 5. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. Number 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Let's talk about justifying circumstances. Justifying circumstances refers to a situation that there is a crime that happened. However, the accused cannot be considered a criminal because his or her act is justified. In other words, the accused committed no crime. He or she was justified in his or her acts. Number 1 of Article 11 speaks of self-defense. Number 2 of Article 11 speaks of defense of relatives, either consanguinity or by affinity, within the fourth civil degree. The fourth civil degree is up to first cousin. Number 3 of Article 11 speaks of defense of strangers. Number 4 of Article 11 refers to a case wherein a person causes an unintentional injury to another because that person is currently facing emergency situation and he or she tries to avoid that evil or injury. This may be called instinctively self-preservation or survival instinct. Number 5 of Article 11 refers to a case wherein the person committed damage or injury to another while he or she is fulfilling his or her duty, or he or she is lawfully exercising his or her right or office and without negligence or imprudence in fulfilling his or her duty. Number 6 of Article 11 refers to a case wherein the person committed damage or injury to another while he or she is acted in obedience to an order issued by a superior for some lawful purpose, and that he or she is not negligent or imprudent in obeying the order. Self-defense cannot be justifiably appreciated when uncorroborated. It is settled that when an accused admits harming the victim but invokes self-defense to escape criminal liability, the accused assumes the burden to establish his plea by credible, clear, and convincing evidence. Otherwise, conviction would follow from his admission that he harmed the victim. Self-defense cannot be justifiably appreciated when uncorroborated by independent and competent evidence, or when it is extremely doubtful by itself. Indeed, in invoking self-defense, the burden of evidence is shifted, and the accused claiming self-defense must rely on the strength of his own evidence and not on the weakness of the prosecution. Please note, in justifying circumstance, no criminal liability, hence, no civil liability incurred. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. Number 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony or delito, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. Number 2. A person under 9 years of age. Number 3. A person over 9 years of age and under 15 unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this Code. When such minor is adjudged to be criminally irresponsible, the court, in conformably with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5. Any person who acts under the compulsion of irresistible force. Number 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. Number 7. Any person who fails to perform an act required by a law when prevented by some lawful, insuperable cause. Let's take note, in exempting circumstance, there is criminal but exempted. And since exempted, there is no criminal liability, but there is civil liability. Number 2 and 3 of Article 12 is amended by Republic Act Number 9344, Section 6. Minimum age of criminal responsibility. A child 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. However, the child shall be subjected to an intervention program pursuant to Section 20 of this Act. A child above 15 years but below 18 years of age shall likewise be exempt from criminal liability and be subjected to an intervention program unless he or she has acted with discernment, in which case such child shall be subjected to the appropriate proceedings in accordance with this Act. The exemption from criminal liability herein established does not include exemption from civil liability, which shall be enforced in accordance with existing laws. That's all for this video. Thank you for watching.